Welcome to Module 9. In this module, we focus on the ethical responsibilities of professionals in the private lending space, particularly attorneys and brokers, as well as the emerging regulatory issues tied to fintech and online lending platforms. Let's begin with ethical pitfalls. Attorneys and brokers in lending transactions must be especially vigilant. Dual representation, serving both lender and borrower, creates serious potential for conflicts of interest. Inadequate disclosure of terms or risks can lead to unenforceable agreements or malpractice claims. Brokers and non-lawyers must avoid engaging in the unauthorized practice of law, especially when drafting loan documentation. Under California rules, attorneys must obtain written consent if they represent both parties in a transaction and must clearly explain the risks. Similarly, brokers have a legal duty to disclose all material facts. This includes property defects, borrower financial issues, and any relationships with other parties to the loan. Transparency isn't just good practice, it's legally required. The lending landscape is rapidly evolving. Fintech companies now offer peer-to-peer and online lending platforms, matching borrowers with investors directly. These platforms raise new issues, ranging from borrower screening to cybersecurity. Are these platforms lenders, brokers, or both? That matters because each role comes with different legal obligations. California's Department of Financial Protection and Innovation, or DFPI, has expanded its reach under the California Consumer Financial Protection Law. Fintech lenders are now explicitly within their regulatory scope. They must comply with rules prohibiting deceptive and abusive practices and are subject to examination and enforcement actions, just like traditional lenders. This raises the important policy question: should fintech lenders be regulated the same way as traditional CFL licensees? Some argue that increased oversight is necessary to protect consumers. Others claim that overregulation could stifle innovation. We'll open this up for classroom debate. Think about whether the existing rules strike the right balance. Let's wrap up with a case study. Imagine an attorney who regularly represents a hard money lender. A borrower asks this attorney to draft documents for a loan from that lender. What should the attorney do? First, assess the potential conflict and advise the borrower to seek independent counsel. Second, disclose all material information in writing. And third, document everything carefully to avoid future disputes. Thank you for joining this session. In our next module, we'll explore what happens when a borrower defaults and how lenders can respond under California law.